This was not a new arrangement. This was someone.
20
So, what did you do? I asked him to please stop. That was her answer. The full story was worse. A 9-year-old boy had a 4-month-old infant on his back on the living room floor. He was holding the baby's legs or ankles. He was twisting the baby back and forth across the carpet. And the adult who was being paid to supervise these children, the licensed daycare provider, saw all of it. She didn't rush in. She didn't take the baby away. She didn't even raise her voice. She looked at a fourth grader swinging an infant by the legs and she asked him to please stop. And then she told him to pick up the baby and play nicely. When Judge Judy heard those words, she did something that almost never happens in that courtroom. She laughed, not a small chuckle, an explosive, incredulous, heard round the gallery laugh that told you everything you needed to know about where this case was headed before a single ruling was issued. That laugh is where we begin. It is the sound of a legal defense disintegrating in real time. And what led to it is a case study in how not to run a daycare, how not to supervise children, and how a licensed professional's own words can become the single most damaging piece of evidence in the entire proceeding. The year was 2015. The place was Idaho, and the plaintiff was a woman named Tiffany Walker. She was a nurse, a mother of 3. She understood the fragility of an infant's body in a way that most people never have to. Her youngest child was 4 months old. She had been taking her children to this particular home daycare for nearly 2 years. Her older kids had gone there. The baby had started attending when he was just 7 weeks old. This was not a stranger. This was someone she trusted. On the morning of July 2nd, 2015, Tiffany Walker dropped off all 3 of her children. The baby was perfectly fine, healthy, normal, a 4-month-old doing what 4-month-olds do. She went to work believing her children were safe. A few hours later, she got a phone call from the daycare provider. The baby wouldn't stop crying. Her to pay. She was told to come pick him up. When she arrived, she found her infant son in distress. Within hours, doctors discovered the truth. The baby's leg was broken. A 4-month-old with a fractured bone. Surgery followed. Medical bills piled up. And the daycare provider's response was not an apology. It was not a frantic explanation. It was a calculated denial. She claimed she had no idea how it happened. She suggested maybe the baby was just having a bad day. Maybe he was constipated. Maybe it had nothing to do with her. Tiffany Walker sued for $5,000. That was the maximum allowed in this court. It would cover part of the medical expenses. But the money was almost secondary. What she wanted was accountability. What she got was a masterclass in how a courtroom can expose the truth that a state investigation failed to find. Let's meet the defendant. Her name was Heather Scherer. She was a mother of 4 herself. She had a 12-year-old, a 9-year-old, a 7-year-old, and a 4-year-old. She was a licensed daycare provider in the state of Idaho, operating out of her own home. And on the day in question, she was caring for between 10 and 12 children. 10 to 12 kids. Her 4. Tiffany Walker's 3, and 4 to 6 others. She was not alone. Her husband was there with her. 2 adults. A dozen children. Among them, a 4-month-old infant who required constant supervision, who could not roll over reliably, who could not defend himself, who could not tell anyone what hurt or why. Now, a license to operate a daycare does not mean you can take in unlimited children. Every state sets ratio requirements. The number of caregivers must be proportional to the number and ages of the children. When Judge Judy asked Heather Scherer how many children she currently cares for, the answer was staggering. 10 to 12. By herself. Her husband had gotten a job elsewhere. The woman who couldn't prevent a baby from being swung around a room when there were 2 adults was now solely responsible for the same number of children, and she still had her Idaho had not revoked it. That detail alone should make you stop and think about what licensing actually means and what it doesn't. The legal concept at the heart of this case is negligence. Negligence has 4 elements: duty, breach, causation, damages. A daycare provider has a duty to exercise reasonable care to protect the children in their custody. That duty is higher than the duty you owe to a casual visitor. It is a duty of heightened vigilance. When you accept money to watch someone else's child, you are effectively becoming a temporary guardian. You don't get to be casual about it. You don't get to delegate that responsibility to a 9-year-old. And you absolutely do not get to see a child being twisted by the ankles and respond with a gentle request to play nicely. The transcript of the defendant's own account is devastating. She was in the kitchen with her husband. It was lunchtime. The baby was in a swing in the living room, which was one large open space connected to the kitchen. She was not in another building. She was not behind a closed door. She was within view. The baby started crying. The 9-year-old brother of the baby took him out of the swing. The baby stopped crying for a moment. Then the crying started again. Heather Scherer turned around, and what she saw should have triggered an immediate physical intervention. The 9-year-old had the baby on his back. He was holding the baby's legs or ankles. He was twisting the baby back and forth across the floor. That is the motion she described. Twisting a 4-month-old by the legs. The force required to break a baby's leg is not small. Infant bones are not brittle twigs, but they are not designed to withstand torsion. The biomechanics of that kind of twisting motion are exactly the kind of force that can cause a spiral fracture. And yet she did not run over. She did not shout. She did not take the infant into her arms. She asked him to please stop. And then she told him to pick up the baby and play nicely. Play nicely. Those two words will echo through the rest of this case. They capture the entire failure in a phrase. A 9-year-old does not have the judgment to understand what is safe for an infant. Children that age are still developing impulse control. They can be gentle or they can be rough. They can be loving or they can be curious in ways that are physically dangerous. An adult is supposed to be the barrier between that curiosity and catastrophe. Instead, this adult outsourced her duty to the very person who was causing the harm. Now, this is where the case takes its sharpest turn. Because when Tiffany Walker sued, Heather Scherer had to file a written answer. She had to explain what happened in her own words. And those words, submitted under oath, became the trap she walked directly into. She wrote that she saw the 9-year-old playing rough with the baby. She wrote that she saw him holding the baby's legs and swinging him around the room. She wrote that she told him to play nicely. And then she wrote that when the baby continued to cry, she looked again and the older brother was still not being gentle enough. She told him he wasn't playing correctly and to put the baby back in the swing. The baby never stopped crying after that, never stopped crying. A 4-month-old screaming in pain for hours. And still, she didn't call the mother to say something was seriously wrong. She called to say the baby was fussy. She suggested constipation. She did not mention the twisting. She did not mention the rough handling. She did not connect any dots because connecting the dots would have meant admitting fault. And so the baby suffered. Surgery followed, a broken leg. And when the state investigated, they said there wasn't enough evidence to charge her with a crime. That is a crucial distinction that many people misunderstand. The state's decision not to file criminal charges does not mean nothing wrong happened. It means the burden of proof for a crime, beyond a reasonable doubt, was not met. Civil court is different. Civil court operates on a preponderance of the evidence. More likely than not, 51%. And in civil court, the defendant's own words can meet that threshold all by themselves. That's the legal education piece. Criminal versus civil, different standards, different consequences. Just because you aren't arrested doesn't mean you aren't liable. And just because a government agency decides not to act doesn't mean a judge won't. Now, back to the courtroom. Judge Judy has been reading the defendant's written answer aloud. She has been building toward a single question. The gallery is silent. The plaintiff, Tiffany Walker, is sitting in the back, reliving the night she held her screaming infant in the emergency room. The defendant is standing at the podium, still apparently unaware that the words she wrote have already doomed her. And then Judge Judy looks up from the paper and asks the question that will trigger the collapse. So, what did you do? The defendant doesn't hesitate. She repeats the line that she clearly thinks sounds reasonable. She says, "I asked him to please stop." The courtroom is still for 1 beat, 2 beats. And then Judge Judy laughs. It is not a laugh of amusement. It is a laugh of sheer disbelief. The kind of laugh you make when words fail you because the absurdity is so profound. It is a laugh that tells every person watching that what they just heard is not reasonable, not acceptable, not even within shouting distance of competent adult behavior. The gallery laughs with her, not at a joke, at the collapse of a defense. That laugh is the emotional climax of this case. It is the moment the entire narrative pivots from investigation to judgment. Because what Heather Scherer didn't understand is that a judge doesn't need a smoking gun when the defendant hands over a signed confession of negligence. The confession wasn't that she broke the baby's leg. The confession was that she saw dangerous conduct and responded with words instead of action. In a daycare setting, that is the breach. That is the failure. And that failure, more likely than not, caused a 4-month-old to suffer a broken bone. Think about what reasonable care looks like in that moment. A reasonable daycare provider sees a 9-year-old swinging a baby by the ankles. She does not say, "Play nicely." She separates them instantly. She checks the baby for injuries. She documents the incident. She calls the parent. She does not return to cooking lunch while the baby continues to cry. The standard of care is not optional. It is the floor below which you cannot fall without being legally responsible for the consequences. And Heather Scherer fell through that floor the moment she decided that a verbal instruction to a child was a substitute for adult supervision. The ruling, when it came, was swift. Judgment for the plaintiff in the amount of $5,000. The counterclaim for legal fees, filed by the defendant because she had to hire a lawyer for the state investigation, was dismissed. That counterclaim itself was revealing. She wanted the mother to pay for the attorney she needed when she was investigated for what happened to the mother's child. The audacity of that request only underscored how deeply she failed to grasp her own responsibility. The baby thankfully recovered. Tiffany Walker later said he is perfectly fine now, but the scars of that day are not just physical. They are in the memory of a mother who had to hear her child scream through x-rays. They are in the trust that was broken between a parent and a caregiver. And they are in the public record of a courtroom proceeding that made one thing absolutely clear. When you are entrusted with the safety of the most vulnerable people in society, you don't get to deflect. You don't get to blame a child. And you don't get to hide behind a state investigation that failed to act. Here's the lesson you can take with you. If you ever find yourself in a situation where a child is injured in someone else's care, understand this. The criminal justice system is not the only path to accountability. Civil liability does not require proof beyond a reasonable doubt. It only requires that your version of events is more believable than theirs. And in a case like this, the caregiver's own contemporaneous statements, the things she wrote down, the things she admitted to seeing, those become weapons. They can be used to show that she knew of the danger and failed to respond appropriately. That is the legal definition of a breach of duty. And once that breach is established, the dominoes fall: causation, damages, liability. Heather Scherer's defense was that maybe the baby was having a bad day, but a bad day doesn't break a leg. Twisting does. And when you see a child being twisted and your only response is a polite request, you have just written the plaintiff's case for them. Never underestimate the power of your own words. They can be your only defense, or they can be the very thing that buries you.